Thank you very much, Averengwe, and to everybody that's joined this afternoon. It's an absolute pleasure to be with the team, particularly under these circumstances. I think everybody, and particularly those people on the team's call that know me, we unfortunately often only get to meet under very difficult circumstances when things have already happened. Here we have a slightly different opportunity, and that's to discuss things that are coming and how to address them rather than what has happened. There's a proverb which says, "May you live in interesting times." Not sure whether it's a curse or a blessing, but we are certainly living in interesting times, and particularly in our mining sector at the moment. It just feels as if everything is changing all the time. Every week there are changes to the environmental laws. We've now got the published and possible amendments to the Mineral and Petroleum Resources Development Act coming. There are changes to critical minerals. So every single week there are things that are changing in our sector, and we are certainly living in interesting times. What I'm hoping to achieve this afternoon is to take you through some of the key changes which are coming. So just by way of background in relation to the Mine Health and Safety Amendment Bill, by way of background, the current Act, the Mine Health and Safety Act, came out and replaced the old Minerals Act in 1997. Changes were made in the very first year, major changes. The first version of the bill, the Act that came out was focused on the responsibilities being on the manager. So very similar to the Minerals Act, all the responsibilities were on the manager and very few responsibilities were placed on the employer. The very first changes a year later changed that and moved all the responsibilities from the manager to the employer, and those changes have been with us since 1998. The changes that are coming are the first most significant set of far-reaching changes to the Mine Health and Safety Act since 1998. And it is an important aspect to get our heads around and also to work towards compliance because of one very important thing, and that is subject to any transitional arrangements which may be given by the team, including the Chief Inspector. And there is day one compliance. So the moment that it is passed as an act, we are expected to comply, and you'll see as we go through the changes today that day one compliance is going to be extremely difficult unless we have spent time preparing for it. And when I talk about preparation, one of the key things from my perspective has always been a multidisciplinary approach. So you'll see when we go through the changes, I'm not sure who is on this call today. It's very difficult to see the full range, but if there are members of our teams from HR that are not on this call, it's not good. If there are members of our mine planning that are not on this call, it's not good. If there are members of our teams that relate to procurement and recruitment generally are not on this call, then it's not good. The changes are so far-reaching, it will affect every single element of our mining operations going forward, and unless we work as a multidisciplinary team and we prepare properly, there may be challenges on day one compliance. It's also an interesting time because government is obviously focusing on changes to almost every single law that we have. Our last count, we've got 227 laws that apply to mining, and most of those, or many of those, are changing on a day-to-day basis. You'll also see when I go through some of the changes, there is a money aspect here. What do we mean by that? There are increased fines that are going to be imposed, and I'll go into the detail more, but it's also aligned, and I think everybody's aware of the debates and everything that went around our budget this year. Government is on a drive to collect money, to make up the holes that have been created, and there's a saying in government at the moment to all the departments, including SANRAL, Department of Labour, sweat the assets, and that is genuinely the mantra within many of the departments at the moment, is sweat the assets. So wherever money can be made, it has to be made by government. So it's aligned with a lot of the changes that I'm going to take you through today. So bottom line, before we start, 1, it's great to be here. 2, we live in interesting times. 3, it's a good opportunity to be proactive, and we have some time to put the teams together, look at the changes, and make sure that we can comply on day one. My only complaint today is I thought I had an hour. It was down to 45 minutes. It's probably down to 30 minutes now. Averengwe should know by now not to only give me 45 minutes, but let's see what we can squeeze in the next 40 minutes. I do want to leave time for questions. It's quite important. The questioning session is very, very important so that I can just understand potentially what the concerns are from the members that are participating today. But I think we can start now and run through the presentation. I prepared 30.
Warren, you muted, and maybe that gives me an opportunity to jump in to say the 45-minute limit was merely for your sake. So if you need more than that, please feel free to go through the full range. We've got all the time, to be honest. So the 45-minute limit, you can lift that restriction.
No, that's absolutely fine. I'm sure people will be tired of listening to me by that anyway. So, team, the focus at the moment is obviously on the amendment bill to the Mine Health and Safety Act. The question is, when is this coming into force and effect? The starting point, it was published last year in October. It's already an amendment bill. It's not like the MPRDA where there's a proposal to make amendments and then to prepare an amendment bill. This is already an amendment bill. There is some pressure to pass this bill. We were actually expecting it to be passed in the first quarter of this year, but that has come and gone. And in a couple of days' time, the first half of this year is already gone. There is some pressure to have it passed, but the sense that we're getting is the attempt is to also pass it at the same time that Chapter 2 to the MHSA, the Chapter 2 to the regulations will be passed as well to align with the changes. In other words, Chapter 2, the new appointments, are very, very important. Just on the appointments, and I'll touch on it briefly because it is quite important. Every single day we engage and we have discussions with the mining sector on appointment structures. And no matter how long people have been doing appointments and appointment letters and designing the appointment structures, there are always unique features and there are always concerns around appointments. And when I carry on with the slide presentation, you'll see one of the changes to the CEO. But Chapter 2, which should be passed, and it makes sense for it to be passed at the same time as the amendment bill, is going to introduce a whole range of new appointments. They're going to be consolidated in Chapter 2, and they're going to replace most of the appointments which have been with us for a while. So we've got appointments under the old Mines and Works Act regulations. They became appointments under the Minerals Act and then became appointments under the Mine Health and Safety Act. So we look for appointments in the Act itself, in the MHSA, the new regulations, and in the old regulations. And obviously that does create some difficulty. It's now going to be consolidated under Chapter 2. But just to tell you how long that has been around. So the chief inspector he's Dick Bucker, tried to change the appointment structure. He wanted 5 appointments only per mine, and he suggested the 5. That didn't work. Then Mayor Marnus took over as the chief inspector, and she tried for many years and didn't get the changes done. And then, of course, David Msiza took over, and he's been talking about the changes for a long time. So perhaps under David's reign, we will finally see a consolidated Chapter 2 with the appointments. I mention it purely because it is important. If you are putting together teams and you are considering the changes to the Mine Health and Safety Act, it's important to also consider changes to the appointment structures that are coming. They go hand in hand. So this has been around since October. As I said, the understanding was that it would be passed already, but it hasn't. And the talk is that it will be passed this year still. So sometime in the next 6 months, it will be passed and come into law. So that is the current thinking around the timing, subject to what I've said, that they are trying to make sure that it is aligned with Chapter 2 and the changes to that. There are a number of big changes coming, and as I mentioned, it's the biggest changes since 1998. 5 major changes. Number 1, the duties of the CEO, that is changing, and it comes back to the appointments. I'll get into that in a bit more detail. The second major change relates to the training, which is Section 10. The focus is moving on to absolute training requirements. No qualifications of reasonably practicable. It's an absolute training requirement, and there are 3 or 4 big changes coming there. That's number 2. The third one is the powers of the inspectorate, and in particular the chief inspector, changes to how wide David's powers are as the chief inspector to extend to communities and other persons around the mines that are affected by the mining. It's aligned with the practice at the moment of the principal inspectors issuing instructions which cover communities and people living in structures in and around the mines. But that is quite an important change. The fourth change, which is quite important, is that inspectors are going to be given more powers to take control of mine sites when incidents occur, when complaints and health occurrences occur, going so far as giving them the authority to take a chain and a lock and put it around the gate. So that is quite important. And then the fifth major change or set of changes is the criminal liability and what can happen. And that is quite a major change. There's a reverse onus coming, that the employer is assumed to be in breach of Section 2 of the Mine Health and Safety Act if somebody is injured or somebody dies, there's almost an automatic assumption that the employer is in breach. And then related to that, the increase in the fine. So those are the 5 major changes. I've obviously listed a number of the changes here that are quite important, but those are the 5. If I can summarize it, and again, taking into the time that we've got, those are the 5 major changes that are coming. I'm going to skip over this one for now. We can come back to it depending on the timing. So the first major change that I mentioned was the chief executive officer. So most companies already appoint the CEO, either by way of resolution followed by a letter of appointment or a letter of appointment. That's typically the practice, but it's not currently required. It's not a requirement under Section 2A. But the changes require the CEO to be formally appointed. So that is quite an important. That is quite an important element, so that the CEO must have a letter of appointment going forward. And the current provision is that the CEO must take reasonable steps to ensure that the employer complies with its responsibilities. That qualifier is now gone. So it says the CEO must ensure that the mining company, complies with its responsibilities. And that is around the thinking that CEOs get away with things. It's around the thinking that CEOs are not responsible or held accountable when things go wrong at the mines. And it's aligned with that thinking that the CEOs must now be appointed. They must have, and it's aligned with that principle. If it can't be measured, then people can't be held accountable. So the requirement is a letter of appointment with responsibilities, authorizations, and accountability in that letter of appointment. What is also important in most of the structures that you'll be familiar with at the moment, we often appoint persons under Section 2A3 to take the place of the Chief Executive Officer, and that person then steps into the shoes of the CEO. That is going to go. It says that the CEO must be a member of the board of the company, and the CEO must be appointed under Section 2A1. So it's all around accountability and responsibility of the CEOs and making CEOs accountable and responsible when things go wrong. And you'll see when we get to the changes around the criminal liability and the fines and the penalties that the CEO, it's aligned with those changes, and that the CEO is now going to take probably a more risky role, if I can put it that. CEOs that are used to saying, I've got people and I've got general managers that look after things, I think that era is going to go. And we're going to see more and more CEOs being called to account and deal directly with the Mine Health and Safety Inspectorate. And of course, when there are fatal inquiries, that they sit through those inquiries and are questioned. At the moment, the practice is that the CEOs are only typically called to inquiries if it's a multiple fatality or it's a high-profile fatality. And for the rest of the time, the GMs and the managers sit in the firing line. So one of the major changes. I'm going to just skip this one. The Section 7, again with the appointments and Chapter 2. Currently, any appointments under Section 7.2, which is an employer appointment, or Section 7.4, which is a manager appointment, it's a may. In other words, it's a discretionary appointment. The changes are that they must be made going forward. Basically says where an appointment is not made under 7.4 or 7.2, then the employer, in other words, the person appointed as the 4.1 is required to make sure that those responsibilities are complied with. It shouldn't change anything on a practical level, but it is important to note when designing appointment structures going forward that you do need 7.4s and you do need 7.2s. There are a few mining companies, for whatever reason, their advisors have said to them, don't appoint people in terms of Section 7.4 read with the regulation. It's fine just to appoint them with the regulation. It's not aligned with our view. I think most of you on the call will know our advice has always been do a dual appointment under Section 7.4 read together with the relevant regulation. The changes to Section 7 mean going forward that we have to appoint people under 7.2 and 7.4, and they must be worked into our structures. The amendments to Section 9, quite important. The codes of practice, you'll know that Section 9 has got 2 provisions relating to codes of practice, 1 compulsory codes and 2 discretionary codes, and consultation is currently required with the Health and Safety Committee only on those codes. The amendments basically say that if you don't have a Health and Safety Committee, then the consultations must be held with the health and safety representatives. Now, that sounds okay on the face of it, but can you imagine trying to consult with a range of health and safety representatives? And it's not only practically because of the numbers, but there are usually personal viewpoints at play, alliances, loyalties to whichever trade union the person belongs to. So it's a practical challenge consulting with health and safety representatives, and I don't think that was thought through properly, that you now have to consult with health and safety representatives if you don't have the committee. It's already a challenge. I think everybody knows that on the codes of practice, if you consult with them, with the health and safety committee, a COP, a new one, or amendments to the COPs can take months, if not longer. And if you now have to consult with health and safety representatives who may have a different mandate, that can be extremely, extremely challenging. It extends potential liability as well, where the codes of practice are not implemented or they are not amended appropriately. It creates liability for the employer as well. And obviously it can affect health and safety if there's a code of practice that must be in place to deal with something and it's not in place. It obviously can compromise health and safety in the workplace. Just going to leave that for a moment. Again, I can come back to that. As I mentioned, this is going to be one of the major changes. So at the moment, Section 10 on health and safety training basically says that the employers are required to provide training as far as reasonably practicable. And that definition of reasonably practicable, it's defined in the Act. We know what we're supposed to meet. And if, for example, somebody says we haven't complied with it, we can say, but here's the definition and this is how we've complied with it. The main changes going forward on Section 10 is the reference to as far as reasonably practicable is removed. And it essentially says that every employer must provide employees with required training. This is an absolute obligation to make sure that our employees are trained. There's no to the extent reasonable, there's no to the extent reasonably practicable, and it is now changed. We must make sure that employees adequately trained. So previously it used the words properly trained. It's now going to say adequately trained. Problem is that the word adequately is not defined at all, and it is going to probably lead to extensive debate. Again, you can think practically. So we sit with an HR team or a training team, and we design the training matrix, and we say that a person who is a roof bolt operator must have competent B, they must have confined space training, they must have fire training, etc., and we mark it off and we sign it off and we say that is adequate. The inspectors come and do an inspection and they say, no, you haven't sent that roof bolt operator for training relating to surface fires in the veld. And then we'll have to say, but the person never goes to veld fires. Why should they be trained? Well, that's adequate. So it's going to it's potentially going to lead to some debates around what is adequate. It also is going to require that we must keep records of all formal training. It sounds on the surface, it sounds easy to achieve, but I think everybody on this call, if you're honest, and if you went to your training center now and you said, please give me my file of training, you'll probably find that the training is split up into various areas. Different departments have got training. Remember, training includes PTOs and other types of training, health and safety training during health and safety meetings, etc. I think everybody would be fairly surprised if you try to go and access your training and see whether all your formal training is readily available, and the word is readily available. Again, this comes to two things. One, when inspectors come and inspect and they ask for training records, and people run around and say, no, I'll go and get it here and I'll get it there. And the inspectors get quite upset about that. And that's logical. And then also, obviously, in the inquiries, I've been doing fatal inquiries for over 25 years. I've done over 1,500 fatal inquiries. And I can honestly say that I think in probably 1 to 2% of all of those situations, I was given a proper training file where I could connect the dots. In other words, where I could say this COP with this version number was presented in training in this module on this day to this employee. You simply can't connect those dots. And this is also part of the underlying concern regarding training and led to these proposed changes to Section 10. Part of the training is also that the Health and Safety Committee or the health and safety representatives must be consulted in respect of training. So again, you can imagine the practical difficulties if you don't have a health and safety committee. And I know most mining companies will say they do, but there are periods between elections when they're not there or they don't have a quorum, and it can be problematic. So you have to now consult. It's a new requirement to consult with the Health and Safety Committee or the health and safety representatives on your training. And I foresee blockages and challenges around consultation on training and training modules, including what constitutes adequate training for different categories of employees. Then the definition of formal training has been included, and it basically says formal training is any relevant training contemplated in 10.2, which must be properly structured, documented, and assessed, and aimed at achieving adequate levels of safety and health. What this means is that attendance registers are no longer acceptable as proof of training. So our typical way of proving that participants were at the training is to have at the top of the document, provided confined space COP training today, and everybody who signed this attendance register was trained on this COP. Not acceptable going forward. We have to have a proper proof of structured training, which is assessed, and all formal training that is given must be documented, assessed, and must demonstrate adequate levels of health and safety. It's a major, and I can't emphasize this enough, it's necessary to take a combined approach, multidisciplinary approach, because to achieve compliance with the new Section 10 means we have to work together with a number of departments at each mine to make sure that this is being attended to. In my view, this is probably the most notable and probably the most far-reaching change that is coming under the MHSA, and is really going to need some time and effort to comply with that. I'm just going to skip that for a moment. The amendments to sections 12 and 13, just to cover at the moment, sections 12 and 13 talk about measurements, hygiene measurements and occupational health measurements. The changes to section 12 and 13 are two major changes. One, we must appoint the OMP and the OHP. Not a major problem. We've been doing that for a long time, but there are qualifications that are coming for each of those appointments, and we need to make sure that we comply with those requirements. And then the second major shift is that we are the introduction of management systems. You'll see also section 13, it talks about management systems. The reason for this is, and I think many of you on the call will know about the class actions. The coal class actions followed the gold mining class actions a couple of years ago. And what has come out clearly in the coal class actions and the previous gold mine class actions was that medical measurements does not equate to a proper system. And again, the difficulty of connecting dots between measurement of, say, dust at the face while a coal CM is cutting doesn't equate to connecting it to that person's exposure limit and to the health and safety systems in place, like the water sprays, etc. So you can't click a button and see what the dust exposure was, what it's meant, and what systems are there to address that. And that has come out very clearly in the various class actions. And the changes to sections 12 and 13 are aimed at trying to improve the systems in place at the mines to make sure those can be dealt with. Just, I am going ahead. I will come back depending on the questions and the timing. So there's a new section 19A. And it basically says that it relates to unfitness to work. So where we do a medical assessment on a person and that person is unfit to work, they don't get their certificate of fitness, typically the mines will go through a process of medical incapacity, and that may result in the employee's dismissal for medical incapacity grounds. There is an appeal process against a finding of medical unfitness, and that process is under sections 19 and 20. The changes are that the employer is now required to tell the person that, or to inform the employee in writing that they have been found unfit and that they have a right to lodge an appeal with the medical inspector within a period of 30 days. So there is an obligation on the employer to tell the employee, and then the medical inspector is required to acknowledge the appeal and to process that appeal. The difficulty with the changes, or the challenge with the changes, I mean, on the face of it, again, it sounds rational, it sounds reasonable. Employees must be able to challenge findings of medical unfitness. The difficulty and the challenge is that you could, for example, go through the medical incapacity process. You may end up with a dismissal based on medical incapacity. You may already have been through the CCMA process, and then the medical inspector says, well, I find that the person should not have been found unfit and that your finding is wrong, and therefore you have to take the person back. So we've got a bit of a challenge between the Labour Relations Act, the CCMA, the Labour Court on the one hand, and the processes under the Mine Health and Safety Act. It doesn't have timelines other than that the medical inspector should be looking at the appeal within 30 days. But again, the medical inspector has capacity constraints, and there are a number of medical appeals to the medical inspector is increasing every single week. So the number of appeals is increasing, and the workload of the medical inspector is increasing significantly, and that is problematic. So it opens up the possibility of a medical inspector finding weeks, months, or even possibly years later that the decision to declare the employee unfit was wrong, regardless of what the CCMA says. And that can be a bit of a challenge going forward. We've got a matter at the moment where an employee went through a process assisted by his union, signed a separation agreement, got paid the separation, and then because of the finding of unfitness was unable to secure a new position in what he wanted, and keeps on going back to the Mine Health and Safety Inspectorate. And that has been going on for 3 years because the appeal hasn't been dealt with either. So it unfortunately does open up the challenge. But in summary, we are now obliged to tell an employee. We're also obliged to tell the employee about the right to appeal. If they appeal, it goes to the appeal, and regardless of our medical incapacity process under our labor law side of things, regardless of that, and regardless of what we do, for example, if the person is referred to a momentum or something for medical incapacity payments, all of that can be overridden by the medical inspector saying that she doesn't like the decision and can undo it. So some challenges coming there, which means that we need to look very carefully at our medical incapacity processes and our procedures there. Then, so that I've covered to some extent, I just want to make sure that I cover the key things. So here is another very big change that is coming, the functions of the Chief Inspector. Under Section 49, David has wide-ranging powers. He's got extremely wide-ranging powers. And the one thing which the inspectors have been doing in some regions, most notably in Rustenburg and to some extent in the Northern Cape, the principal inspectors, under instruction from the chief inspectors, issue blanket instructions. So they issue an instruction regardless of whether it's a situation at your particular mine. And if it is, for example, in Rustenburg, there is a significant increase in the number of community complaints. And as a result of that, the PI, Monaghan Matiba, has issued blanket instructions talking about blasting perimeters and 500 meters and what you can and can't do. And that has been challenged. Many of the companies have been challenging that. Sorry, I'm just taking a sip of water. A lot of the companies, the mining companies, have been challenging these blanket instructions. And that hasn't obviously helped the situation where there have been so many community complaints. So what the changes are to Section 49(7) is that the chief inspector or the principal inspector can, under instruction from the chief inspector, issue instructions on any matter affecting the health and safety of employees or persons who are not employees but who may be directly affected by the activities at the mines. In other words, communities. So this is giving David the authority, together with the principal inspectors, to issue instructions on matters that are affecting communities and other persons in and around the mines. And if you look at the changes and the guidelines that have come out on dust, noise, blast, vibrations, etc., we're going to probably see many more blanket instructions in future issued by the office of the chief inspector. Then another change, and I mentioned that the inspectors are getting more and more powers. This Section 57A, I think everybody on the call knows about the famous Section 4s, and we deal with those on a daily basis. And I don't think any of us on the call would say that the inspectors need any more powers because they've got everything under Section 54. But in any event, the new Section 57A basically says that inspectors may, in order to collect evidence for the purposes of a Section 60 investigation or a Section 65 inquiry, they can issue a prohibition. So similar to under the OSH Act, they can issue a prohibition. I don't see what the difference is to a 54 on a prohibition, but they're getting this additional power to prohibit certain things, not only issue a Section 54, and they can block, bar, barricade, or cordon off a site in such a manner that the inspector may consider necessary. So the inspectors has now been given wide-ranging powers to stop and to barricade and to close a site. I mentioned at the beginning that this basically means an inspector can arrive there with a chain and a lock and put it around the gate. Why do I mention that example? Because it's already happening. So it's fairly typical that the Mine Health and Safety Inspectorate, when changes are coming, they start applying the principles when they do inspections and things like that. And we've had 2 examples now, literally where the inspector arrived with the SAPS. The allegation was illegal mining, and not Zama illegal mining, but the allegation was that the mine had gone beyond the boundary pillar, and the inspector with the SAPS literally arrived with a chain, put it around the gate and said, you can't go into your mine. And so this is the thinking of where we're going there. So it is quite serious. And the prohibition can also be given verbally, but it is supposed to be confirmed in writing within 24 hours. And it is only revoked when the inspector has reason to believe that the necessary evidence has been collected. So wide-ranging discretion then. It can be a day, it can be a week, it can be a month, it can be a year. So it is concerning that in addition to Section 54, we are now going to face a Section 57A scenario where prohibitions are going to be issued in addition to Section 54. Again, please don't take my criticism of the section as me not being in support of health and safety. Of course I am. And all of you on the call that know me know that my passion for health and safety. It just creates so many difficulties, though, when you have multiple provisions dealing with essentially the same thing. And again, acknowledging capacity constraints, acknowledging different experience levels, these provisions do become challenging. Just going to cover that. Next major change, amendments to criminal liability. So at the moment, if the employer or any appointees or any employees breach the Mine Health and Safety Act, they can be criminally prosecuted. I think everybody on the team on the call knows that practically when there have been serious incidents and or fatalities, there are very, very few successful prosecutions. There are very few matters that actually get referred for prosecution. And the reason is because that takes time. So again, constraints in our magistrates court and in our high courts, capacity constraints, prosecutions for health and safety matters don't always get priority. And again, any clever lawyer will be able to push that matter out for years just by using the rules of court and by finding the loopholes. A prosecution can start months or years after the event and then can be pushed to 4, 5, 6, 7 postponements. And, a matter can be comfortably managed by a half competent lawyer for 3 to 5 years. So it's not a good position to be in, but it is there. Prosecution of companies, the employer, not too many of those, and where there have been recommendations for prosecution, they have not been successful except for minor charges. We've seen many more prosecutions for environmental non-compliance than we have for health and safety non-compliance. So what are the amendments doing? They're doing two things. One, there is an assumption that if the employer has contravened Chapter 2, and Chapter 2 is the broad responsibility to provide a healthy and safe working environment. If there has been a breach of that and somebody has been injured or fatally injured as a result of that, it is assumed and that the employer has breached that and can be found guilty. And there are some interesting words, and you'll see that the employer is deemed to be guilty unless, it's found guilty, particularly if the employer has conspired with the person concerned. So interesting wording. And I often get asked the question, what does it mean that the employer conspired with that person? Well, if the GM sits in a boardroom and says to the manager, don't worry, just do that, I want my production, that's conspiring. Or HODs are sitting in a planning meeting and they say, no, don't worry about that. Carry on, do what you need to do. I want production. That is conspiring. And also if you're sitting in a planning meeting and you're going to do a plant shutdown and people say, no, well, the grating is loose on the first level, that is conspiring. So all of these provisions are coming in, and the only way that the employer can get around that is if it turns, so there's a reverse onus, and let me just put it this way. So basically, the employer is deemed to have breached unless the employer can prove three things. One, that the employee was acting without the connivance or permission of the employer. In other words, without in some way saying that the employer presumed it or assisted or instructed it. So that's the only way, the first thing that the employer must prove. Number two, it wasn't within the scope of the authority of the employee. In other words, employer has to show that what the employee did was so far outside of their scope of authority that it could never be authorized. A good example is that we authorize an electrician to do MV switching, and the employee goes into a substation and does HT or high voltage switching. Then we can say honestly that the person was never authorized to do that, and they were only authorized to do MV switching. But if the electrician goes, say you're authorized to do MV switching, but you can do it in substation A, B, and C, and the employee goes and does it in substation D, we won't get away with it, because the court or the mine health and safety inspectorate will say, well, the person is appointed to do MV switching, and therefore it's broadly within their scope of authority. And then the last thing that the employer has to do as part of this reverse onus is that it has to demonstrate that the employer has taken all reasonable steps to prevent the act in question. Again, you can imagine how difficult it is going to be to demonstrate that all reasonable steps were taken. You have to think of everything. For example, if you've got a guard over a tail end, a drive of a conveyor belt, and you've left 1 centimeter at the top between the top grate guard and the side guard, and there's 1 centimeter or 2 centimeters. Now, you wouldn't think that somebody would put their hand in there, but somebody may want to put their hand, and we would be criticized if we didn't close it completely and say, well, you didn't take all reasonable steps to prevent a person from putting their hand through the grate. So it is significant. The reverse onus is significant. It's basically an introduction of that the company is guilty until it proves itself innocent. And it's to obviously help the situation I mentioned earlier, that the courts are constrained and criminal cases take forever to go through the system. And I just want to emphasize, one of the defenses that we often hear when we're preparing for inquiries is, no, but I instructed all of my team members that they weren't allowed to do it, or here's an instruction saying that they weren't allowed to do it. Going forward, that instruction on its own is not sufficient. It will not fall within the category of all reasonable steps. You have to take it so much further. I often get asked questions, does that mean that it must be a one person, one supervisor scenario? The obvious answer is, if you take this provision to its logical conclusion, yes, but logically, no, that's not what it means, but you have to show what is reasonable. How do you show what is reasonable? You always show objective decision-making. So following a management of change process, multidisciplinary, in other words, do not do desktop risk assessments and make decisions on your own. Always have people with you. I know some of you have heard me say this before, but we apply the 2 heads, the 5 minutes, 2 heads scenario. In other words, you always wait 5 minutes before doing something, and you always speak to at least one more person. In other words, the 2 heads, so that that perspective, different people's perspectives, can be taken into account before taking any action. So what is reasonable, we'll have to show with reference to objective decision making within structures like management of change. And then I think just on that point, I think some of you may have seen last week there's a guideline on management of change that was gazetted on Friday through David's office. So the whole management of change emphasis is out there. The Mine Health and Safety Inspectorate is expecting more and more from a management of change structure, and the guideline was issued on Friday last week. Then the other element that I mentioned was increased penalties. So we've got the reverse onus, and you're guilty until you're proven innocent by the employer in respect of everybody else. So all other people that can be prosecuted under the Mine Health and Safety Act, that is innocent until proven guilty, but for the company, it's guilty until proven innocent. What can happen if the company is found guilty? Currently, there's a schedule of fines, and they range between 200,000 and 5 million. What has changed now is that the fine is linked to turnover. So it can be up to 10% of your annual turnover of the company. So it's problematic from a couple of perspectives, particularly mining companies that have got mining rights held by the same company. So company A has 3 mining rights with 3 different mines. If this comes in exactly this wording, the fine can be up to 10% of the annual turnover of the employer, whether it's at mine A or mine A, B, and C. And obviously the court's ability, when it's imposing this fine, the court can also suspend or withdraw the prospecting right or the mining right. The fine is calculated, as I said, of 10% of the annual turnover in the preceding year, and it is also, or can be worked on the exports, whichever is higher. So if a company makes more money from its exports, then the 10% will be calculated on the value of the exports from South Africa. So it's potentially a significant penalty that can be imposed. If people have been keeping up with some of the announcement, you'll see that ICASA threatened to impose a 5.2 billion million rand fine on Google. It's linked to similar concepts, in other words, percentage of turnover in the country. So there are a number of factors that the court must take into account before imposing it, such as justice, interests of justice, the nature of the offence, whether we've committed offences before or not. And on this point, I just want to make a very important point. The Section 11.5s. So we have to submit SAMRAS forms when incidents or accidents occur, and you have to do 11.5s for significant incidents and accidents. We found that in a lot of cases, the mines do 11.5s when they shouldn't be doing 11.5s. And when we read the 11.5s, it's basically admission of liability. And to get the PI off the back, we basically say, we're sorry, this is how we messed up, and here's our systems failures. Going forward, all of those types of admissions can be used against us, can be taken into account when determining the amount of the fine that is going to be imposed on the employer. So it's like speeding tickets. Eventually, you get 20 speeding tickets, and then you get prosecuted for reckless and negligent driving. All of your speeding tickets that you've paid are admissions of guilt and get taken into account when you're prosecuted for reckless and negligent driving. So the same principle applies here. So we need to be very careful on our 11.5s and first of all, whether we should be submitting them in the first place, and if they are submitted, what they look like and what we say in those. That can be used collectively against us. Also, if administrative fines are imposed following a recommendation to impose an administrative fine, payment of those admin fines, again, are admissions of guilt, and collectively they can be used against us. And also when we said we're doing upliftment presentations on force, we have to be careful on what we admit in those. All of that gets taken into account. In addition to the fine on the percentage of turnover, the fines in the schedule, in Schedule 8 have increased. You'll see that depending on some of the fines, they go between 1 million and 4 million per item, and some go up to as much as 8 million. Up until now, the Mine Health and Safety Inspectorate have taken a fairly pragmatic approach to these fines. They've done it collectively. In other words, there are multiple offences, they do it collectively. It is the company is fined collectively for all of the breaches. But technically, each breach can result in its own fine. Very similar. Members of the audience are dealing on the environmental side. You'll see that if you contravene NEMA and the Water Act, you get fined per offence, and you can end up with 20, 30, 40 million rands worth of fines if you're not careful. But the same principle can apply now. I've just included the slide on the changes to those. And then lastly, I just want to cover some of the definitions. It's aligned with the changes to the MPRDA. So the first one I want to mention is the definition of employee. Don't believe it was necessary. If you look at the definition of employee at the moment, it says any person who's employed or working at a mine. It covers everybody. It covers the service provider employees, but the changes are specific, and it says including any person working for an independent contractor. Don't think it was necessary, but it has been done, and it makes it very clear there's no us and them. It's everybody working at the mine is an employee for the purposes of the MHSA, and they're an employee for the employer, the company that holds the right to prospect or mine. So even if you've got a contractor for the Mine Health and Safety Act, that contractor is not that employee's employer. So that's around the employee. The employer definition is also amended, basically excludes the independent contractor. So it's making it very clear that the mining company is the employer and is the responsible party. So that has now been made very, very clear. Not sure if there were any companies that challenge this. Maybe there were, but I've never seen the reason to change this. I think everybody understood it, but obviously some mining companies challenged that in the past. Also, the geographic area is being extended. So the mining area is being extended to pretty much anything that is connected by way of a pipeline, cableway, conveyor belt, road, forms part of the broader mining area. This can obviously go to ridiculous lengths. If you've got for example, a coal washing plant 40 kilometers away from the mine, how can it possibly be part of the mine? The intention of this change is to make sure that plant or that staging area or loading area forms part of the mine, and you can't getting out of liability for anything that happens there. So extending the scope of responsibility of the employer in relation to the mine. This has also come around, and I think many people on the call will remember that there's been a debate on what is the mine, and it came up in a couple of cases, the Burt's Bricks and the Terra Bricks judgments being the more famous ones, where the Section 54 was issued to both in Burt's Bricks where they were extracting the clay, but it was also issued for a forklift that was, according to the inspector, substandard at the brick-making section of the operation. And the court basically said the brick-making activity is separate from mining, and therefore the Section 54 couldn't be issued for the brick-making section. And there have been a couple of judgments after that. So what these changes are, they're trying to make sure that what the courts have separated, the DMPR is putting back together. So that's the change there. So yes, extension of the mining area and making sure that the responsibilities are getting wider and wider, including for communities, as I mentioned, with the new powers for dam and season. So I have now been talking for, I think, 55 minutes. I'm going to stop and manage a few questions.
Aaron, thank you for that. To point out the obvious, deeply insightful masterclass, just unpacking what we can all expect. I'm pretty sure we have a few questions. We've got about 10 minutes to go through the questions that will arise. I'm hoping we can take a few. So please, if you are on the line and you've got a question, we've got Warren here for the next 10 minutes. And maybe whilst we wait for questions, Aaron, I'm going to take the opportunity just to project our associate members who make these masterclasses possible. These are companies and institutions that help Coaltech deliver on its mandate. But yeah, again, I'm hoping that we can take a few questions. So you can either unmute or you can add your question under the chat box. Happy to read it out.
Can I go over in?
Oh, please.
Hi, Warren. Can you maybe just display that last slide again on the mining area definition?
This one here, or the previous one?
Why don't you need to reshare?
Yeah, we'll do
I
that.
think the question relates to mining area, and you said any area that's linked, and there was a pipeline, I assume, in between as well.
Yes.
And the answer is probably how long is a piece of string? How long do you separate specific activities that's not related to any mining activity to be part of the mining area?
No, there has to obviously be some connection to the mining operations. So part of the definition is your starting point is always the area which is the prospecting right area or the mining right area. So that's described in your mining right or your prospecting right. So it starts with that. Then it says any adjacent or non-adjacent areas on which mining related operations or incidental to mining are being carried out. So that's the next level, the next circle. And then the change is any area connected to area A or area B by means of any road, railway line, power line, pipeline, cableway, conveyor belt, which is under the control of the holder of the right. So it has to be connected to your mining operations. Number one, in other words, the hole in the ground, or it is connected to an area next to the hole in the ground, which you are using for mining. Then if it is connected by road, railway, pipeline, etc., and it is under the control of the employer, then it forms part of the mine. So that is the major change. The two things: one, it must be connected by means of one of those things, road, rail, etc., and it must be a place which is under the control of the employer of the mine. So there is some limitation, but you're right, it is potentially how long is a piece of string. I think we've been our own worst enemy. We've always tried to exclude sidings and water treatment plants and training centers, and obviously this is a backlash against that to bring everything back under the scope of the inspectorate. And we have debates about this a lot of the time. I mean, it's part of the constant debates with the inspectors, but it's going to be more difficult going forward once this change is in.
Thank you for the clarification.
Thanks, Rolf. Just checking one last time if we've got any other questions before we adjourn. And I also did note that there were a few people who came in and out. So in case you missed some critical insights, the meeting or the masterclass will be made available on Coaltech's YouTube channel. We'll publish it at least by Friday. So if you need to refer, it will live there indefinitely. I saw a hand. Please go ahead.
Hi, Warren, Peter Dupree here. I just would like to know, I don't think it's anything in terms of this amendment, but Chapter 6, Section 16 that has been amended in terms of the amount of rescue teams that needs to be on a mine. Is there a possibility that you can clarify that anything above 150 requires 2 teams? Is there any pushback from industry that you can maybe respond to?
Peter, there was pushback when the drafts came out before. So it's the missing person locators and section and Chapter 16. So there were a number of engagements between Minerals Council and the DMPR and tripartite. That time for pushback is unfortunately gone. And to the extent that there are concerns around compliance, the companies are applying for exemption. I'm not aware of any exemption having been granted yet. I'm skeptical. I don't think that exemptions will be granted, but the time for talking is come and gone. Unfortunately, there's no time for pushback on that. It is in place. We have to comply with it, and the only way around it is an application for exemption.
But Warren, is it also again about interpretation of the law in terms of if you have, for example, 2 different addits,
Yes.
do you add those employees together, or is it per addit?
No.
In your opinion?
It's interpretation again, and I would say it's per addit.
Okay, thank you very much, Warren.
Great. Thank you. Warren, it's 4 p.m. I'm not seeing any hands. I think all that is left for me to say is every time as Coaltech we come knocking on your door, Warren, you always say yes. So we really do not take that for granted at all. Just based on the level of engagement and participation today, it is clear that the insights you shared are much needed in the sector. So thank you as always for your time, the time it takes to put together the slides, but also the time it takes to deliver the insights. So from all of us at Coaltech and the broader coal community and beyond, we really do appreciate and value your time. Thanks again to also those who work in the background, Angela, Carmen, Niara Media. Thank you for making this possible. And to everyone else, we hope to see as many people as possible on the 1st of August when we go through our annual ideation session. For Coaltech to be clear on what we need to focus on next year, we rely on insights from the coal community so that the R&D activities that we carry out do in fact address industry needs. With that, I'm going to adjourn the session. Thank you. We'll see you in a month at our new hotel in Benoni. Until then, thank you very much for your time.
Thank you, everybody. Cheers.